Thank you. I'm going to jump to one case on the 10 o'clock docket because which is State of Kansas versus Laura Lee Kendall Miller, case number CLW 2023 CR 69. Can you hear me, ma'am?
Yes, I can.
I spoke with Mr. Metcalf this morning, and I think he has conflict, so he has to be.
Can I represent myself, please? I don't need an attorney.
Very well, I will discharge Mr.
When a defendant tries to play lawyer without even knowing the basics, disaster is basically guaranteed. Laura isn't just confident, she's downright defiant. But courtroom bravado has an expiration date, and it usually spoils the second. Reality smacks you in the face.
What, sir?
Maybe I misunderstood what you said. You want to proceed without an attorney and enter a not guilty plea, is that correct?
That's correct.
Thank you. I will enter a not guilty plea. Mr. Audie, we probably need to have a in-person hearing. Do you want me to set this for a status hearing or a pretrial conference?
That's up to the court how you want to set it procedurally, whether you want to set a pretrial conference or just set it for a bench trial or a jury trial if Miss
Jury trial when I'm completely innocent and you're taking eyewitness testimony from people that aren't even in Walmart. And I am going to subpoena the video footage there. And this is a complete waste of my time. This is the second time I've had to appear, the second lawyer.
Here's where the clash really hits. Laura sees herself battling a system stacked against her, but a courtroom isn't a battleground for personal wars. It runs on rules, evidence, and restraint. Her outburst might feel like passion, but to the court, it's reckless and it can shred her credibility in seconds.
I mean, I don't agree with the trial. It's completely unnecessary. And I know I have
Ma'am, you just,
trial.
ma'am,
I have the right to waive a jury trial.
set the matter for a pretrial conference, and you will have your opportunity to discuss what you want the court to hear about the merits or whether or not the matter should proceed to trial. But we have to have that pretrial
I waive a trial hearing. I'm sorry. I don't need, I know I have a choice to let you decide or let a jury decide.
I'm going to set the matter for
myself. I want you to decide.
Would you please move to her?
Demand for a bench trial comes off less like strategy and more like a reckless gamble. Waiving a jury doesn't just speed things up. It changes the entire game. The judge tries to keep things on track, but Laura keeps pushing back. Locked in a standoff of her own making.
Like 4 or 4:30, so that way Miss Kendall doesn't have to take the whole afternoon off.
I'll be glad to set it on May 10th at 4:30 in the afternoon. Ms. Kendall Miller, will that work for you?
She's muted. Just a second.
You have to unmute yourself.
It's a small but telling shift. Despite Laura's defiance, the judge and prosecutor show empathy, bending to fit her work schedule. A rare glimpse of humanity in a courtroom world that usually gets remembered only for its clashes and chaos.
I have counsel appointed to me at this point, and then also that the court addresses me as Laura Kendall, my legal name for the past 6 years.
Yeah, Your Honor, her name changed and the court system for some reason keeps putting it down as Kendall Miller, but yeah, her name is Kendall.
Hey, so I apologize about that. I'm sure we can adjust that in future pleadings. So with the correct name matter addressed, do you have an objection to setting the matter for May 10th at 4:30 p.m. for a pretrial conference in person in this courtroom in Winfield?
An objection? I'm okay with that date and time.
And ma'am, did you request another attorney be appointed just now?
A heartbeat, the tone, changes. Laura asks for an attorney and softens how she speaks to the court. It's a reminder that beneath the defiance is someone still searching to be heard, even if it comes out tangled and conflicted.
Let's set it for attorney review for May 3rd at 10 a.m.
Okay.
Anything else we need to address on this matter?
I don't believe so. And Laura, just get in touch with Scott and then he should be able to appear for you and you wouldn't have to take off work that morning.
Okay, I'll call him. I'll get his information. Scott Loftus. Thank you so much, Mr. Audie.
Laura,
you.
if you hang out in the hallway, I'll bring you that information and get your address.
Thank you. I appreciate you.
Interview moving from a pretrial to an attorney review shows the court bending yet again to adjust for circumstances. It's a careful dance between legal procedure and personal needs, but the more twists and turns in this process, the longer it takes to reach a real resolution.
Have anything on it?
Let me read to you what the allegations are. Jackie Hunt, your court services officer, alleges in this affidavit that on April 4, 2022, you were granted 12 months probation from a sentence of 12 months for battery on an LEO, and that you have violated the terms and conditions of your probation, being condition number 2, in that you were directed to report to your court services once per month, but that you have violated it by failing to attend scheduled appointment with Ms. Hunt on April 3rd, that Ms. Hunt called and left voicemails on the phone number that you had provided and did not get responses back from you, and that you failed to contact her office and reschedule within 24 hours of missing an appointment. Do you understand what the allegations are?
This case breaks from the usual courtroom drama. It's no shouting, no fiery clashes, just silence. Her violation isn't loud, it's absence. Missed calls, missed check-ins. But in court, silence speaks volumes, and to a judge, it often reads as one thing: non-compliant.
Mr. Audie, do you know what your request is regarding bond in this matter?
I don't actually have a copy of the PV affidavit, so I would just leave that to the court.
Ms. Newsom, where do you live?
I live in Art City. I'm technically homeless, but I have a job and I'm working on getting me my own place.
So do you have a place to stay if we release you?
Yes, I could stay at the Osage in Art City.
Your Honor, she is held on a domestic battery also that I don't think's been filed on yet.
Okay, well, that will make bond moot, no doubt then. So what I will do is continue this matter to May 3rd, 2023 at 9 a.m. I've appointed Chad Giles, and we will address bond either on the 3rd, or if the other case comes before the court here in Arkansas City, we can address bond at that time. In the meantime, she will be held without bond.
Interview, it's a tough one. To watch, Allison is technically homeless, juggling a job, and clearly trying, but with a pending domestic charge, the judge's hands are tied. There's no room for leniency here. It's a stark contrast to Laura's fiery defiance, showing that even the quiet, less dramatic failures can carry heavy consequences.